Just like introduce myself. I know most of you. I've met you most of you fairly briefly, but I've been working in this space. I'd like to say 25 years, but it's probably a bit longer than that. I don't like to admit that. I went and had a lovely facial today to try and hide that. But I've been an HR manager, and I've worked in big multinationals. I've been in big banks, and I've come back to Bendigo. I grew up in Bendigo. Went to St Mary's College. And I've come back. I met my husband and married here and had my children here, and then we sort of went off again. But I've come back now to settle with the girls and have very happily and proudly opened my own employment law practice again. So I'm delighted to be doing that. I might cut across a couple of these speakers tonight. So I'm going to go through some of the stats fairly briefly because it's probably not my sort of space. But I suppose the thing I want to point out here is that drug use is on the increase, like even amongst this sort of bracket, which I think I fall into, is on the increase. So I think it's a really important topic that needs to be addressed and talked about because, you know, drug abuse or drug use doesn't stop at home, it spills into the workplace. So it's important. So let's talk about why it's important for employers to look at it. I mean, the first thing is, of course, the dollars. Drug and alcohol use costs businesses in Australia approximately $6 billion annually, like staggering figures. Lost productivity. But from my perspective, it's about liability, legal liability. As you all know, because you're all business owners or HR professionals, employers have a lawful duty to provide a safe place of work. Impaired workers, of course, pose an increased risk of harm to themselves and to others. And they may breach, if someone is impaired at work, even if there's no incident, just being impaired breaches the legislation because it's not providing a safe workplace. So as an employer, you have a positive duty to act to eliminate or control at least the risks in the workplace. I've used a lot of this information from this great book, Important to Press, and I'm happy to provide that better reference later if people want it. It's a really useful reference. Well, when it comes to meeting your health and safety obligations, when it comes to drugs and alcohol, first you might identify what the risks are that drug and alcohol use poses in your workplace, assess the level of those risks, and then implement your control measures. Let's talk about assessing. I suppose the key is what's the likelihood of an incident? And I suppose I like to give the example of if you're in a retail shop or if you're running or you're driving heavy machinery, or like in Nicole and you guys' workplace, operating underground detonators, it's very high, you know, so the likelihood of an incident and the consequences. So what are the consequences of an incident? You know, a fatality, permanent disability or injury. So then you look at, am I a high-risk workplace or a low-risk workplace? And I think it's important too to look at that because the Commission and the courts, they look at it like if you're a low-risk workplace and you put a zero tolerance in, I'll talk about this a bit more, you know why, that's disproportionate, it's a disproportionate response. And if you sack someone who turns up to Katie's, is Katie still in operation? Am I showing my age there? Katie's to, you know, then is that a disproportionate? But if you sack someone who's detonating mines, you know, or detonating explosives, I mean, is that a disproportionate response because it's a zero tolerance? So you've got to also just, you know, be sensible in the, so obviously the higher the risk level, the more important it is to implement controls. So what can you do? Obviously, drug and alcohol policy, testing, education and training, and directing workers. I think this is really interesting. So if someone starts taking medication that might affect their, you know, impair them, have something in your policy that they have to tell you. Or even if they turn up to work a bit hungover or a bit drunk or a bit whatever, that they tell you. Like it's better that they tell you than they drive heavy machinery and kill someone, you know. So, and it's done in a non-punitive way. But I think Chris will talk a little bit more about that as we go on. In a high-risk workplace, you know, obviously this helps minimise the risks to health and safety. And obviously, if it's going to have a serious impact, if a breach will have a serious impact, then you really should be looking at drug and alcohol testing in your workplace. When and who should you test? You can, of course, do pre-employment testing, but only with their agreement. It's a little bit fraught, so you need to be careful there. Reasonable suspicion testing. Are you talking about all these things, Chris? A little bit? Are you talking about these?
Yeah.
Yeah, okay, so I'll just whiz through them because he'll talk about them. Random selection. So this is maybe testing your whole workforce, but randomly selected. targeted testing, so either particular groups of workers. So if you have a workplace that drives heavy vehicles, maybe you just test those, but you don't test the admin staff. Self-testing and mandatory testing, perhaps following the involvement of a safety incident. Again, I'm sure my colleagues will talk about this, but it's very important about who administers testing. It needs to be someone qualified. You've got a nurse on site, Angela, haven't you? A registered nurse?
We have 2 qualified nurses on site, but we also have
an independent
employees who are trained as accredited collectors.
Yeah, and this is a third-party provider as well to test. And that's good because it's arm's length, it's independent, and it's got certainly rigorous standards. So. There are 5 different types of tests. I've only put 3 down to keep you in suspense. But there's breath, urine, and oral, and of course my colleagues will talk more about that. And there's different sort of testing regimes and requirements for each of the different testing. These are the standards. These are the standards governing drug and alcohol testing. They're not mandatory, but from a legal point of view, what I want to point out is that it's highly recommended you follow them, because to a court, it shows consistency and compliance with your obligations to the health and safety legislation, and it shows that you take it seriously. And it may mean a court is more likely to regard the evidence as reliable because it's been done in a consistent way over a period of time. I'm going to talk about policy. I'm going to go a bit more into legal now. So I'm going to talk about drug and alcohol policies. I go on and on and on about policies. Nicole gets sick of me talking about policies all the time. If you come to my seminars more often, you'll get sick of it as well. But you need to have policies in place to do pretty much anything. So for this, you'd need a drug and alcohol policy. Privacy policy. I'm not sure that many of you would realise you really do need a privacy policy for the drug and alcohol testing. And I'll talk a bit more about a case that was this year that considered that. Obviously, an alcohol and safety policy and a disciplinary action policy, what you're going to do if someone tests positive. When you look at implementing a drug and alcohol policy, it's really important to take a step back and think, what do you really want to achieve from that? Like maybe if it's just a healthier, happier, safer workplace, maybe just coming down like a ton of bricks with a 0 tolerance is not the way to go, because people get suspicious and they get, disgruntled, and they think all they're trying to do is punish us and, get rid of us and sack us. So it's really important to really take a step back and go, well, why am I implementing this policy, particularly if it is in something not mining or not heavy machinery, so have a good, you need to think about that. And the question is, some workplaces, as I've mentioned, do need a 0 tolerance, absolutely need a 0 tolerance, others don't. So is your workplace high or low risk? If it's low risk, like an office or a retail shop, your policies just should outline behaviours expected. So it's okay to go out for lunch with clients and have a few drinks. And that's part of your policy, or 1 drink, you can even specify it, because it's a low risk work environment. Like if it's high risk, then you might have to have a 0 tolerance. But this is what I'm getting at. You must be able to justify your 0 tolerance. If you're standing, I always say to people when they say, do I have to do that? I go, well, imagine yourself standing up in the federal court before a judge and him asking you, why did you do that? And I think if you can answer the question, then okay, do whatever. But you've got to be able to answer the question. So why you have to justify that your workplace warranted a 0 tolerance. So if you sack someone in a retail shop because you have a 0 tolerance workplace and they challenge it, they could successfully challenge it, saying it wasn't a reasonable policy. We didn't need to have 0 tolerance at our workplace. It was they just implemented that unnecessarily. So again, take a step back. We'd all just go, yep, 0 tolerance. Anyone who breaches is sacked. It's just sort of, but it's probably not as simple. Well, it's not as simple as that. I'm sure you've all implemented policies, but I think some of the important things to remember with policies, some of you will have enterprise agreements and be covered by modern awards that have consultation provisions when you implement new policies. Some smaller businesses won't. So it's just some key things. Obviously, consult with key stakeholders. If you've got unions or all those sorts of things, please consult with them and talk with them. Communicate the policy to all the workers and give them training. Make sure they understand the policy and why you're implementing it and the consequences of breaching it. and make sure they sign off. I did something for one of my clients in the room this week. I won't say who, but I really love to see the training, the signature. They've done the training. There's evidence they've done the training. There's no excuse for the breach. The method you will use and why, who's going to conduct the testing, who's going to be tested, how often, when additional, like maybe following a workplace incident, the levels that are acceptable or not acceptable, and what disciplinary measures you'll take if A, a worker refuses to undergo testing, or B, if they test positive. This is an interesting case of this year. The worker, does anyone know this case? He refused to be tested. So they can be disciplined for refusing to be tested if, but only if, their employment contract says that they can be tested and they've signed it, and the drug and alcohol policy says that as well, and the policy outlines the consequences of refusing. And you can only obviously conduct it when a worker consents. The above is taken as consent. When you join a company and you sign and you say, yes, this is an interesting case. I'll talk about it quickly. He refused. He was doing fingerprint scanning. They were introducing it's very popular and fashionable to do this fingerprint scanning now. And he didn't want it because the employer didn't actually talk to him about how they were going to, they didn't look at the Privacy Act and say, well, this is someone's personal information. It's actually their sensitive information, which, as you would know, has got a higher level of security. He refused to give his biometric data. He was dismissed. And the reason they said was he failed to follow a lawful and reasonable directive. He went for unfair dismissal. He failed at the first instance. They said that he did fail to follow a reasonable and lawful directive. He sought an appeal, and the appeal was granted because the courts thought that it was a novel area of emerging law, this biotech stuff. And it was upheld. The full bench of the Fair Work Commission said that it wasn't a lawful directive, that he had to submit to the collection of his fingerprint data in circumstances where he did not consent. And what they also did as employer, which we're all tempted to do, to say, if you don't consent, we're going to discipline you or sack you. And they said, well, that's not actually consent. If someone's going to be sacked, it's not really actual consent, it's not genuine. From this case, in the end, because I always wanted to know, my law lecturers talked to me about cases, I said, well, what happened in the end? In the end, he actually had the dismissal overturned, and he was able to go back to work, but the Fair Work Commission held that the relationship was so damaged with his employer that he would agitate and cause so much trouble at work that they did not force a reinstatement. So he didn't win that. But this is lessons. Consent must be informed, taking into consideration the Privacy Act. I've just done some work for a client where I did alcohol health and safety policy with the privacy legislation taken into consideration. This is what I've just said. Policies and contract clauses must be in place beforehand, and you need to provide a collection notice. A collection notice, for those of you who know, is just telling your employees where you're going to store the data, how you're going to store the data, and who's got access to it. There's a prescribed format. It's pretty straightforward. Can you force an employee to take a test? As the above case demonstrates, really no. And if you do something sneaky, it needs to be in their employment contracts and policies, and you can't physically force by sort of stealing some of their DNA or their whatever, because they can take legal action against you for doing stuff like that. So we can't do that either. It could be assault or whatever, so you've got to be careful. If it's not in your employment contracts, it's a tricky area. You've got to somehow get it in. As you would know, you can't just unilaterally vary an employment contract. You've got to have the consent of your employees to do it, which they may not consent to. Sometimes you can do something with, consideration, like maybe give them a bonus if they sign the new contract, something like that. If they still refuse, then that's when you probably need to get legal advice, particularly if you're wanting to do a zero tolerance or something and it's really important to your business. What to do if a worker tests positive? As I've kept talking about and harping on about, it needs to be proportionate. So the Fair Work Commission is a funny body, and they're sort of a bit kind sometimes, so they like to look at the personal circumstances as well. Like, it's a whole thing about, is it really harsh and unjust to sack this person? So let's look at a couple of quick cases. He had 18 years of work, unblemished work history. He came with a low blood alcohol level. They sacked him. He became homeless and in desperate financial circumstances. And he took the unfair dismissal. He took action, and the Fair Work said, you must consider their personal circumstances. I mean, it's not the only thing you consider, but you can't, you've just got to take, he had 18 years of unblemished work history. I don't know the absolute details of that case, but it did seem quite an extreme response. But then you have another one. He was found to be fairly dismissed. He had more than double the company's permitted limit. He also had a long-standing record. But this was different. The company had a real mandate of safety. And like I know Nicole's company, it's a real mandate of safety first. They had a strong policy which they communicated and distributed regularly and often. The dismissal, this is really important too, it was consistent with approaches that the organisation has taken with other people. So it wasn't like they just singled this one person out and sacked them. The Commission is really big on that. Whatever you're going to do, be consistent. And this was interesting. He didn't show that he was willing to give up his drinking ways. So the Commission thought that he was going to keep breaching, so they said no. Okay, checklist. I can give this all to you, but it's just something to consider. I spoke to someone when I was trying to get them to come today, and they're going, oh, no, we're fine. If they breach it, we just sack them. And I'm going, oh, whatever. Look at the workers' length of service, their position, their duties. Was it prescribed medication? Was there a similar offence? Has there been past warnings? Their personal circumstances, like that case said. The level of misconduct, like do they come to work absolutely, off the scale? Was there an incident? What was their response? And all of it. We can go through them. The likelihood of another breach. And importantly, do they have an addiction? That's a fraught one. Can you discipline a worker who uses drugs? Oh, wait, yep, this is another case. This guy was a union steward. He didn't like a workplace investigation that happened at his employers. He was right. Apparently it was a pretty shoddy investigation, but he got really annoyed about it to a really ridiculous level. He was drunk and he actually had some mental health conditions, but he was sitting in his hotel room sending aggressive, rude texts to everyone. Then he went to work and started abusing everyone and threatening them. He was not at work when all this happened, but they still sacked him. And as we'd all be familiar with the recent Facebook cases, the connection between out-of-work conduct and work is getting narrower and narrower. The unfair dismissal claim failed because it said that he breached the code of conduct, which stated that any out-of-hours conduct that affected the health and safety of employees was a breach. So if you abuse someone on Facebook or if you ring them and abuse them, that's a breach of the code of conduct. What if a worker has an addiction? I'll just say that. It's very complicated because you've got the anti-discrimination legislation then kicking in. Then you've got the health and safety legislation. So then you've got, I think it's on a case-by-case basis, what the breach is, what the workplace is. It's not a really straightforward answer. Creating a healthier and safer workplace, which I think what Chris is going to talk about, and I think Sheena's talking about. But many organisations provide lots of support to their workers. I think what inspired me, I don't know if I mentioned at the beginning, was when I met with Chris and he was talking about, the effects. I mentioned it, the effects when you can just sack someone quite blatantly. They can have on the whole community. So many organisations, and I know Sheena's organisation does this, provides posters, EAP sort of support. They go to the workplace and talk to people. And I think it's great. Not only do you retain valuable workers, but it's good levels of morale because the employees believe that you actually care about them. It's not just about, well, you breach, you're out the door. Train your managers. This is really important too. I think this is important, how to appropriately question workers who they suspect may be under the influence of drugs. You've got to be careful how you phrase things. Get them to understand the legal risks associated with drug testing. Identify drug paraphernalia. I wouldn't know what drug paraphernalia look like, but anyway. Recognise the key indicators of drug and alcohol abuse. So you can do some training for workers. I don't know if you do that, Chris.
We did, and there's a couple of people that attended.
Yeah, good. Okay.
Recently.
You can discipline your workers, which is where you call me if you want to sack them and discipline them and do all sorts of things. But you can support them. Employee assistance program, rehabilitation strategy. And I said some of the other speakers can speak to that. So there's my brochure. I finished. The visitors will be happy. I've given my brochure with prices on it, but tonight, like I did at my last seminar, I give 40% off for a micro business, which is 5 employees and less, and 25% off for other businesses who want to sign up for any of the services offered in my brochure. So thank you.